Good afternoon. One of the big changes that you may have noticed is that we now have a parenting time docket. We started it as a part-time docket to hear all parenting time motions. It's now, as of May 1st, going to be done 5 days a week. And one of the things that you need to be aware of on that docket, whenever you have a parenting time enforcement issue, it used to be that you would be bringing your order to show cause in front of the assigned judge. And I think in an effort to try and keep these parenting time problems from escalating, we are following the statute, which says that a parenting time enforcement complaint should be filed. There's no fee for that. And so you take it to our scheduling office, and you'll get a date in front of Referee Shavy. And then, if it's a persistent problem in parenting time, he is going to initiate a show cause in that extreme case that requires it. The other big change in Wayne County is the scheduling of our motions. You do file your case still. It's a 928 for any domestic relations case. But then if it's a post-judgment motion that will be heard by the friend of the court, you are going to be going to, on the same floor, 900A. And we have a friend of the court scheduling office located there. And you will get a date for your hearing on the same day that you file your motion. We do sign ex parte orders in Wayne County. A couple of the things that we've noticed is that the complaints are not consistent with the verified statement in terms of who's living in the home, who's moved out of the home. They're not consistent, and so it's difficult for a judge to sign the ex parte order if your orders or your complaint and ex parte order are not consistent. And for that reason, I think that most of the judges do like to see separate orders for custody, status quo orders, and injunctive orders, because that way, if there's something wrong with one of them, we don't have to deny them all. You can still get some of the work done that you want to get done, and we can just direct how it should be fixed in order to enter the ex parte order. One of the really important things in Wayne County, because of the volume of cases, is attaching past orders to motions. It doesn't happen very often. And so the judge needs that. It's going to be required if you're filing a post-judgment motion at front of the court. It's going to be required that you attach relevant orders, because the referees don't have that always at the tip of their hand. So we're asking for your assistance in attaching orders to your motions. So if you can help us run your guidelines before you come in with the numbers that you have available to you, and that will help expedite your case as well. We've adopted a policy. The judges, we have 12 judges. They may make some modifications in their courtroom, but generally the policy is that if you haven't appeared for the referee hearing, you're not going to get a de novo hearing. You can file a motion to set aside the order. There are exceptions to the rule, but generally speaking, a motion for a set aside of the order is what will be required. In Wayne County, we do not require the parties to appear for the case management conference. It's heard and scheduled. That first conference on a DM is 90 days from the filing. And it is required, of course, their presence for a settlement conference date. And in Wayne County, we also have a super alternate assigned for the week. The PPO judge on a Friday is the super alternate for the division in the event of an emergency situation. That's who would be hearing the case. So those are the few things I did want to mention. I'm going to let Zanelle make a few points for you too.
I'll just go over some points briefly. First, I wanted to reiterate what Suzanne and also Lynn Davis was saying about the JIF form, the Judgment Information Form. Oftentimes, we don't receive those at the front of the court. That is the information that allows us to put that income withholding out there and really start enforcement quickly. So if you can include that when you're entering your orders, that will help us do our job, and it'll probably make your clients a lot happier. One of the things that I've noticed as far as being in the front of the court is when parties come back for assistance or questions with front of the court, they don't have their information in any organized fashion. So it would be worth it if you would have your clients go purchase just one of those dollar binders where they have all their orders there and they can easily make reference to them. And if, for instance, we're missing something, they can actually say, well, this order hasn't been added onto the system and we're not digging to try to find that order. We ask that the attorneys come to the court at the time scheduled for their motions. We ask that you be prepared. We ask that you bring a copy of the motion and a copy of the prior order with you as well. When you do come to the motion and you're waiting for your case to be called, please utilize that time to talk to the other side. Maybe you can negotiate a settlement and actually appear before the referee with a consent instead of having the referee wade through all the information and trying to make a determination from there. For our parenting time, our default overnights is 75 overnights for the non-custodial parent, unless you have a parenting time order in place that says something specifically otherwise. If there has been a practice where the parties are doing something differently, they need to bring some compelling evidence for that referee to make that determination. Just one party stating that something different will not be something the referee can rely upon. For our parent outreach, we have the Kids First program. All our divorce with children cases are referred to that program at the time of filing. Additionally, we have Mom and Dad, I Need You, and that's the parent education program that we use for our never married parents. One of the things that is going on at the front of the court right now is that we're sponsoring a mediation, the 40-hour domestic relations training mediation under the 3.216 court rule. And we're partnering with the Wayne Mediation Center. So Wayne Mediation Center is giving volunteers, we train them, and then at that point in time, they perform 24 mediations over a 24-month period on cases that we've assigned. And then they are fully certified and are able to do whatever else they want to do regarding mediation outside of the court. As far as the modification and recognizing the downturn in the economy, what we've done is if you come to the window and you advise the person at the window that you have been laid off, you're not currently employed, that person at that time will take information to start the review process of your support. So right then where you're at the window, the review process chain is open and the MISES documents are then mailed out to the parties. If the parties have their pay stub and they're showing that more than 50% is being taken out and they're in that circumstance where they're getting unemployment or whatever, we will go ahead and adjust the income withholding right there on the spot too. Most of the information that you can find out about Wayne County, in addition to what you have in your handouts, is posted right on our website. And the website is www.3rdcc.org. So if you go to the website, you'll see a lot of postings there. And additionally, if you join the Wayne County Family Bar Association, we do updates there. And the Bar Association hosts an annual nuts and bolts seminar to make sure everybody has information available to them. We have an attorney hotline, and that attorney hotline will answer any attorney questions that you have, whether you need to know, as somebody pointed out, the arrearage, what is owed to mom, what's owed to the state. That information will be readily available. We ask that you call, that you make sure that you have either filed your appearance in that case or you have a waiver from the party so we can divulge the information. And if you leave a message within 48 hours, you're getting a call back with the information requested. One of the biggest problems that we find at the front of the court is parties do not give us an updated address. So even when we're not talking about domestic violence and the alternate address, parties actually move and we don't know where to send money to. We don't know where to send the legal notices to and things like that. So when working with parties, your parting comment should be to them, remember that provision in your order that says within 21 days if you change your address, let the front of the court know. If you do nothing else in your lifetime, let the front of the court know where you are. And then, of course, if you meet somebody you're representing them, tell them to check the state of Michigan Treasury website to see if they have any escheated monies up there.